That should last. Yeah, that's true. I will, if it goes down,
So he told me this phone was more like
right.
so I'm curious on why so this is what he did.
Please, all rise. Vertical insertion over the paramount setting. Thank you, may be seated.
Good morning.
Ladies and gentlemen, please will step on the side and for me to turn off the cell phone, please. Thank you.
voice a little bit. Hey, Jamie. Chat. Thanks for being here. Sorry, I had to go late, Jill. With lots of things about the last motion. I tried to start yesterday. I'll go.
she's in a lot of like mixes that I listen to. Tyler Childers was my number one.
Yeah, you should.
Yeah.
Because I listened to Sniper like 100 times. His new album.
Oh.
I listened to that like 1,000 times. It's really good. It's really good. Timeless, that's my jam, dude. It might be yours too.
My two favorite MPAs.
Yes.
Anybody?
Hello, Roger. What can we do for you?
Does anybody have Eric Calvé?
No, not I, but I can find out who does. It's 10 right
Your face.
Listen.
I mean, it's only mine.
You meant she's
She's my number one.
There you go. Good answer.
She's my number one. Well, we did the co-defendant already, and it was bound over. It's the same.
Sometimes you can't control the client.
Maybe. Is it today?
See. Not a
Petro? Oh, yes, I do. Is the, no, they're not here. I was gonna just do the DUI. The officer's here for that, so we can, I mean, that's for child abuse, and we can just do mandatory minimums of DUI. So, I have the officer here, we'll just talk about the SFSTs and the costs and as they find, but, I mean, I'll keep the offer open and see. Yeah.
Good morning.
Good morning.
We're ready for argument on the Tiffany Mackey case.
State versus Tiffany Mackey is case ending 4159. Mr. Carr for the state, Mr. Evershed for the defendant who's here. And we're dealing with the state's motion in limine. I saw the briefing on both sides from that. Mr. Carr, do you want to provide further argument?
Sure, I'll just briefly recap the argument that's kind of been made in the motion already. And just so that we're all on the same page, just to briefly state the relevant facts. A police investigation into Ms. McKay started in July of 2023 and continued on for about a year. But the bulk of that investigation occurred up to about December of 2023. But at some point after charges were filed in the case and the substantial majority of the evidence was collected, officers, specifically Detective Anson with the Sandy Police Department, executed a warrant at Extra Space Storage, which was a storage unit where there was probable cause to believe that Tiffany was keeping evidence of the crime of financial exploitation of a vulnerable adult. Ultimately, the execution of that warrant did not yield any evidence, either for the prosecution or for the defense. Nothing came out of it. However, after the fact, sometime earlier this year, a complaint was made against the Sandy City Police Department for the detective's actions on that day, where it was alleged that so what specifically happened is that he found property in the storage unit. Much of it was labeled in the victim's handwriting as belonging to one of her 2 daughters. The detective seized that property and distributed it to the daughters with the understanding that that property was something of like a fruit of a crime, and that she was not in lawful possession of it. Obviously that was a bit hasty since there was no judicial order to that effect yet. That's what the complaint was based on. That complaint was sustained in a letter that was signed by Sandy's chief of police. An investigation was done by a lieutenant. So my understanding now is that that lieutenant and chief of police have been subpoenaed to testify in our trial, and I'm moving to first exclude any mention of this portion of the investigation, and secondly, if not, to exclude their testimony. And the grounds for that is relevance. That portion of the investigation is simply irrelevant because, again, this is a year-long investigation, and well before that, the substantial majority of the evidence was already collected, charges were already filed. Nothing that happened on that day, that was seized on that day, is expected to be used at trial for either side. There's simply nothing relevant that happened on that day. I understand that sometimes allegations of an officer misconduct or not following policy could be relevant in a trial, absolutely. If there's some reason to believe that the evidence in the case is somehow altered by that or affected by that, but the complaint that was made was solely about this particular part of the investigation that happened about a year after the investigation began. It doesn't relate to any other part of the investigation. No evidence was collected as a result of that, so it is simply not relevant. There's no other reason to mention this part of the investigation other than to say that on this day an officer violated internal policy. But the question is whether the defendant committed the crime that she's charged with, and I fail to see at all how this is relevant to that question. I've read the defense's reply, and the argument seems to boil down to it's related to a police investigation, and investigations are inherently relevant, therefore it's relevant, but that is just asserting a conclusion without actual statements or facts to support it, and I don't think that that is a necessarily categorically true assertion. There are plenty of investigations where not every single part of it is relevant. Take a drug trafficking investigation where a wire is set up and on one day no material calls are found, but maybe evidence is found after that or before that. That day, nothing happened that's relevant because there's no evidence and nothing that affects the case. The same thing with an assault investigation where the person being interviewed says, oh yeah, and last week he took my car. That's not relevant to the crime of assault, and that wouldn't come in at a trial. And the same principle applies here, where yes, the probable cause supporting the seizure was related to the probable cause supporting our case. But nothing happened on that day that's actually relevant to the case. So I sympathize if property was taken mistakenly or if the officer did make a mistake, but that is ultimately a civil issue to be dealt with in another court and is not grounds for forcing something that is otherwise not relevant into a criminal prosecution. So that is the main point of my argument, that nothing about it is relevant and it should not come in at trial. If it is relevant to any extent, it's barely relevant, and there is a great risk of prejudice posed by admitting this, mostly just starting a witch hunt against the officer when, like, again, this is a case that's built on the testimony of 15 to 20 different witnesses, families, friends, expert witnesses, doctors, physical evidence. None of this case is, or, you know, Some of items seized by Detective Anson on other days will be introduced as evidence in the case. Some of his observations months and months prior to this, the subject underlying the motion will be introduced as evidence. But the case is not built on his credibility whatsoever. But if this complaint comes in and there's no reason to believe that it affects any of the evidence in this case, it creates a suspicion that's not justified that somehow the case is flawed, that the investigation is flawed. It would take time out of my case and out of the defense's case to address this, potentially with multiple witnesses. And it's simply misleading and confusing, and given that it has very little probative value, that value is substantially outweighed by the prejudice posed by introducing this complaint. Because it's not just the investigation that's being sought to introduce, it's a complaint about a part of an investigation that's irrelevant in the context of a broader investigation. So then putting that aside for now and just focusing on the testimony of the two witnesses that were subpoenaed, that is particularly prejudicial, right? One of these witnesses is the chief of police. The only involvement he has is that he signed a letter that sustained the complaint. I don't know his involvement. It's likely that it's the same way that District Attorney Sim Gill's name is written on most of the things that I submit, but I would be the person to talk about that, not him, certainly not the chief of police in this case. It creates this view that the issue is so central to the case that the chief of police himself has come in to testify, and that is very misleading. And then for the lieutenant himself who did that investigation, now we're talking about an investigation about an investigation. It's also confusing. It would take a lot of time out of the case. And it's simply not necessary when, again, if evidence on this topic is going to be admitted, simply asking the officer about it is sufficient to address the issue. I know that in defense's motion they raised a claim that it's not ripe to address now because I could be objecting on relevance grounds or admissibility grounds. I'm making that objection now, so if the court rules on that now, I wouldn't be objecting to relevance at trial. And if the court is inclined to admit that, I could stipulate to its authenticity, not necessarily its admissibility, but that removes any need for the chief or lieutenant to come in to testify and authenticate the document. So with all of that said, calling these two people to testify is very cumulative and prejudicial, and thank you.
Thank you. Mr. Evershed?
Your Honor, the timeline in this case is somewhat relevant. In mid-2023, my client moves in with her friend that she had worked with, Gloria West. At that moment in time, Gloria West, who had been abused and mistreated by her daughters, also then makes a change in her estate plan, effectively disinheriting her daughters, which of course caused great grievance to them, and having my client, who's literally been taking care of her for a long period of time and was her friend in the world, to have her estate plan and to have her estate. 3 months later, to the surprise of many that it happened so quickly, she then passes away. My client goes through the legal realm of commencing a probate petition in November 2023 to handle all of this, to make sure that things are done appropriately and through the front door. But during the same period of time, in this half of 2023, the daughters of Gloria West begin to talk to Detective Anson and do a fantastic job of getting him to believe pretty much by every measure only their side of events, and he commences an investigation that looks like is only to go with one side of the story. In fact, telling my client's civil attorney at the time, I'm going to do everything in my power to get this property back to the daughters. So that's the way he viewed it, and that's the way literally everything comes to pass, at least in terms of the defense's case. It is appropriate for the defendant to present her case, to present her side. We understand it's wildly difficult for the prosecution to deal with a key fact in this case, that the lead investigator was found in a case, it wasn't some case from years ago, some other agency, but it's literally this case, that his own agency came in and found that he conducted misconduct in this literal investigation. Misconduct to the degree that after this whole thing is going, there are multiple civil cases, not least a probate one. While this is all happening, then my client gets charged. Then on May 10th, 2024, he goes to her storage unit. It wasn't Gloria West's storage unit, it's her storage unit. Her name was on the storage unit. He has a warrant and clears the whole thing out. This is her property in her name and in her storage unit. Not only clears the whole thing out, but without court order, without court permission, without any authority of law, then distributes this to Gloria West's daughters. Pretty much fulfilling the prophecy that he had given to my client's civil attorney, saying he's going to do everything he can. This is I mean, what else could be more relevant to a case than the actual investigation of the case, of course. So when it comes to 401 and 402, this is obviously relevant. When it comes to 403, we understand. We can't put on 15 witnesses to go through this entire maze of this one aspect of this case. It's a big case. But we are entitled to put on evidence, and we are entitled to put on a defense. We can cross-examine Detective Anson about this. We can introduce this letter. It pertains to this case. It's highly relevant to this case. It goes to the defense's theory of this case. It's literally manna from heaven. I mean, where else is there a sustained allegation of police misconduct in an investigation that you have that's pending, that's going to go to a jury trial? It's terrific for the defendant, so it's probably unfair for her not to be able to use it. No, in terms of like how we present it, we would submit that we are going to subpoena who we need to subpoena to bring in this evidence. Detective Anson, should be testifying, of course, but the chief literally signed the letter, and then the lieutenant is the one that did the investigation. So we've subpoenaed them. No one else is subpoenaed for this. Now, assuming how things go in trial, maybe we don't need to call the chief. Maybe we do. Maybe we don't need to call the lieutenant. Maybe we don't. But this is all a trial issue. I think for today, it's like, well, have we cleared the hurdle of relevance? I think by any degree we have. When it comes to 403, there's no reason other than it's wildly embarrassing to the state to have such a letter that bolsters the defendant's case. This goes, finally, this very much goes, in terms of like the 403 balancing test, substantially outweighed. There's nothing that can outweigh my defendant's right, my client's right to go forth and present her defense. The only way for her, and the only way really for the jury to understand how this even happened is for them to understand that this investigation was tainted from the beginning. And this highlights that taint, that it was viewed one way. I mean, just as a concluding remark, there's so much that can be said about this. A huge issue in this case is the competency of Gloria West. There were literal civil complaints about, improper conduct, and there were attorneys that literally came in and submitted affidavits, 3 of them that came in. And there were LCSWs that were doing hospice care that were talking about competency of Gloria West. This detective never interviewed one of them, didn't talk to one of them. When it comes to the competency issues, like it was always just about one side and one side only. And so when it comes to what the question is today, is this relevant? And does it survive any kind of 403 analysis? Yes. When it comes to the exact way of how this is going to come to a robust jury trial, that'll come down, that'll be handled at trial. I mean, we'll see what's been presented. We'll see what's already in evidence. When it comes to the defense's case in chief, maybe a lot of this is in. And I would just close and just say, when it comes to timing and all of these things, I would just note, for something that's so highly important and relevant to the defense, that's one thing. The defense has 3 witnesses from when my client worked with Gloria West from like years before this whole incident even happened that they're trying to bring in. So when it comes to like, clarity of all of this and trial time and those things, it's a little rich to be hearing that. But anyway, when it comes to this instance, what the defense plans to do is cross-examine Detective Anson on that. We have every right to do that. And then should we need more evidence to present this, we would need maybe 1 or 2 other witnesses. It would be rather quick, but it's really important to the defense to present her argument. And for that, we'd submit it.
I've got a couple questions for you before you leave.
Yeah.
I want to make sure we're talking about the same scope of evidence here. What I'm understanding Mr. Carr to argue, and Mr. Carr, you can correct me if I'm wrong, is specifically the May 10th search of the storage unit, distribution of property, and then the sustained finding from the complaint. That's the universe of what the state is seeking to exclude, not the entire investigation.
Correct.
Right? So with that clarification, Mr. Evershed, tell me why that small piece, I understand the other arguments about, maybe his focus was always misplaced on your client, but as the storage unit and the distribution of property and then the sustained finding of the complaint, how does that make it more or less likely that your client committed the crime with which she's been charged?
Because, Your Honor, we can talk till we're blue in the face to a jury about, a tainted investigation, and that's what attorneys do, and they talk about things and make arguments and do all of those things. But there's something so differently, there's so much credibility that is given when there's a sustained complaint in the actual investigation that substantiates a tainted investigation. In this case, there was a search warrant under the name of this case, using the case number of this case, that went into the defendant's property in this case and cleared out the whole thing. And so when it comes to the investigation, we understand, like, we can still talk about a tainted investigation, but we can also talk about it much more eloquently and with much more power to show the jury, it's like, by the way, you don't need to take our word for it. Sandy City already sustained that part of this investigation was handled improperly. And so is it an argument? It is an argument. Is it an argument that's going to take multiple witnesses and entire days to present? No. It's something that can be contained. It's something that can be handled through a couple of the different things. But, Your Honor, when it comes down to what we have to deal with, which is the rules of evidence, the question is, one, is it relevant? And as everyone knows, and as has been stated in this, does it have any tendency of fact more or less probable than it would be without the evidence? And the fact is of consequence in determining the action. This fact pertains to investigation in this case. This was a search warrant in this case. And this was handled improperly in this case. So as it relates to this case and was a warrant in this case, not something else, it makes a fact more or less probable than it would be without the evidence. So how about the fact or the argument of what we're saying of a tainted investigation and a skewed investigation? Does it make our argument more or less probable to have that evidence? Absolutely it does. Because it's literally on police letterhead from Sandy City PD that says this is something that was handled improperly in this case. So it makes our argument and our view of the case more or less probable by having that. So therefore it's relevant to answer that question.
So the second question is, Mr. Carr's already said he'd stipulate to authenticity. Why do you need the lieutenant and the chief then to testify?
Yeah, and really, and this is where I think it's moot. I mean, not moot, but it's not right. We may not need the chief and the lieutenant to testify. If that's already coming in, if it's already been authenticated, for example, I haven't heard this yet. I haven't heard the prosecution is going to just stipulate to its admission as a piece of evidence that we'll be able to do. So, and if they do that, we haven't heard that yet, then maybe we readdress the analysis as to, like, well, what do we need out of this? Maybe that letter and the cross-examination is going to be sufficient. But at this moment in time, with no trial, we just have to subpoena who we subpoena, and we have to get ready who's going to be here. And if there are stipulations and if there are agreements as to how this is going to come in, then great. Then we may not need to subpoena them. But I don't know that yet. And so for all I know, in a hypothetical world, without that not being stipulated to or entered, they may object on, like, hearsay grounds, like, objection to this on Detective Anson's cross-examination. This isn't his letter. It's hearsay. It's written by someone else. It's signed by the chief of police. It's like, and in that world, if you were to sustain that, which you could, obviously, then I would need to have someone ready to subpoena and say, did you write this letter? Did you do this investigation? And then we can do it. So we're just covering our bases at this moment in time. But if there is a stipulation to it, then that readdresses everything, you know, and we don't need to have witnesses potentially in that scenario.
Okay, thank you.
Yeah.
Mr. Carr, any response?
Yes, and just, before I forget, just to clarify, the state would submit to authenticity, not to admissibility.
What about the hearsay concern that?
That's not
Mr.
something that
Overshoot
I
has?
have figured yet, so it might be something to be given more thought. I don't think I would object to it on, I think I need to give it a little more thought first. But for the moment, just to address the arguments that have been made. Like, to clarify, like, the only complaint that was made, the only subject of the investigation that was complained of was this one particular day with this one particular seizure where no evidence came out of it. No complaint was made about any other part of the investigation. And it is fine and encouraged to present a defense if there are reasons to believe that other parts of the investigation were not handled correctly. Many of the facts that were just given are in dispute. But from what I can tell, the purported, so it's been acknowledged that evidence is relevant if it goes to a fact of consequence. But I still fail to see what that fact of consequence is. All that's being proffered is, this is part of an investigation, so it must be relevant. It's part of the investigation. But that's not, what is the fact of consequence it's going to? And as far as I can tell, what's being suggested is that Detective Anson is biased in some way. There are facts that I'm not sure of and that have been put forward of Detective Anson saying that he will, statements like he'll do everything in his power. I know there's a written fact in here about some interaction with a dog, which I can address in more detail if you'd be interested in. But what this really is a detective who began an investigation not having any involvement with and not knowing either of the parties. In the course of that investigation, he discovered compelling evidence that a crime was committed, and he formed a belief that the defendant committed the crime based on the evidence. And as a detective, as we would encourage them to do, he was motivated to ensure that he was doing a full and proper investigation. Lord knows how many times I have said to people on my cases, I will do everything I can to make sure that justice is done. That doesn't mean that I'm biased. This doesn't mean that the detective is biased, let alone a part of the investigation that, again, is completely separate from, unrelated to other parts of the investigation. No evidence is found. No other parts of the investigation were complained of. This is not evidence that supports that bias either. It feels like a lot of things are being said of, oh, someone who would do this kind of thing is doing the kind of thing that a person who's biased would do. But that doesn't mean that they're biased. Right? Bias evidence is they're part of some group, or they know people beforehand, or they have some motive not based on the evidence. But everything that's being suggested here that Detective Anson has said are things that are coming out of the evidence that he's gathered, the investigation he's done. Again, a lot of it is what we want officers to do. So, again, this is really a civil issue to be dealt with in a civil court, and it's not related to the crime charged. And I would submit on that.
Okay, thank you. Well, I appreciate the arguments today. I understand both positions. I am granting the state's motion in limine today because, one, I don't think it's relevant information. It doesn't go to whether it's more or less likely that the defendant committed the crime that's been charged. Detective Anson's not on trial. Even if it is relevant, I think its probative value is minor and is substantially outweighed by the danger of confusing the jury about what the trial issues are. I think the defense can still make arguments about the detective going down the wrong track and only focusing on Ms. Mackey as a suspect without getting into a search of a storage unit that didn't actually relate or provide any tangible evidence here. And I don't see that presenting evidence to the jury that the detective then had a sustained finding of the complaint against him to be related to this case. So I want to be clear that I'm focusing on that search of the storage unit, the subsequent distribution of property, and that finding by the police department. Other aspects of the investigation, not within the scope of the motion, the court's not excluding those things. But otherwise, the state's motion's granted. Does anybody need any clarification of that?
No.
Okay. How do you want to schedule further here? We had struck the trial earlier, I think.
Right. I think we're looking for that April date for the jury trial.
The week of April 27th. Remind me how many days we had scheduled.
We have 4 days. Yeah. We would need that entire week.
Okay. Does that week work for the state?
It does. Last time we had 4, there was a concern that there might be more. I think it's hard to know, but I've confirmed my witnesses. I have somewhere in the realm of 18 witnesses. Many will be short, others will be longer. I believe the defense has 5 or 6 witnesses.
We have 9.
9? Okay.
And Your Honor, so if we can get the jury trial date of April, we just as a heads up, we are going to be submitting our motions in limine as well, so we would probably need to come back on another argument. We have a couple, just the state is looking to present evidence or from witnesses when they worked, like a couple of years before. We're going to be submitting a motion in limine just to exclude all of that. It's not relevant towards the financial exploitation in 2023. And then, so we have another one just talking about more clarity on the exploitation from the state as well. So we're going to be filing some motions. Obviously, we have some time, so maybe setting an argument or motion in February, and we can work up until then. That's what would be our request.
When can you have those motions filed?
Mid-January, if that's okay.
Okay, so let's have any other pretrial motions filed not later than January 15th.
Okay.
Okay. We'll schedule the jury selection for April 27th. That's at 9:30 a.m. And then we'll schedule the 28th, 29th, 30th, and May 1st as the trial days. Mr. Evershed, do you think at this point we need more than those 4 days?
No. No.
Okay.
I mean.
So here's why I'm asking.
Right.
Right now, I've got another trial scheduled that week that goes into the next week. And so right now, I can block out more time if needed because I've already got time blocked. But if that other trial goes away,
Right.
I want to free up those days for other things.
Right.
So if you think, hey, we might need 5, then I could block it now.
As many as we can get, I think would be appropriate. I mean, really, because even if we exclude these others that the state has, they still have potentially 15. We have 10, and again, relatively minor but important. And so it's just this wild kind of thing of a history of individuals, and anyway, I mean, as many days as we can get, I think would be preferable. But the reason why I say no on 4 is like if it has to be 4, we'll just get it done. So.
Mr. Carr, your thoughts?
I would prefer more than 4. I feel like it's the safer choice. There are multiple expert witnesses in addition to lay witnesses. It is hard to know with such a big trial how many days it'll take exactly, but given the amount of witnesses and expert witnesses, I would feel safer with more than 4 days.
All right, I'll give you also on Monday, May 4th, so that we'll block out that additional day. My hope is that we're still going to complete the trial within 4 days.
Yes.
Because I really don't want to bring a jury back over a weekend just for a little bit more. But I'll block it out just in case we need that additional time. Let's schedule 2 final pretrial conferences. The first of those will be March 31st, and that'll be at 8:30 in the morning. The second will be April 23rd, and that'll be at 9 a.m. So that we're not arguing these others motions in limine on the first final pretrial when we're trying to do a bunch of other things. Let's get a date to hear those motions. Let's see. What about the afternoon of February 26th?
That'll work for me.
That works for the state.
Okay, let's schedule a motion hearing February 26th at 1:30, and we'll deal with those motions in limine. When the motions are fully briefed, please file a request to submit, just so I see what you believe is going to be argued on that day. Is there anything else we need to discuss today?
And just to briefly draw your
Yeah.
attention to this, and this is frustrating, and I apologize in advance. I have filed this subpoena ducis tecum, like it's been issued twice now. The last time I called St. Mark's, they gave me the address that's currently on the subpoena ducis tecum. I called them 2 days ago to confirm that they got it and see what an update was. I was bounced around a lot and ultimately landed with something called CT Corporation, which on the Utah Department of Commerce website is the registered agent for
Right.
St. Mark's.
Right.
And I've been informed that that is the address where the subpoena has to go in order for it to be processed. So I
Okay.
apologize to the court and to everyone involved for how long this is taking. I'm relatively confident that the next subpoena will be completely correct.
Okay, thank you, I appreciate that. Anything else, Mr. Evershed?
No.
All right, thank you. Oh, yes,
Sorry, all other patrol missions are by January 15th?
January 15th.
And then what time for the jury trial days? So where you're done at 9:30?
Right, 9 a.m. for the trial days. Yep, good question. All right, thank you.
Your Honor, we can call Gledhill. Jennifer Gledhill.
State versus Jennifer Gledhill, case ending 2513. Ms. Paulos and Ms. Whiteway are here for the state, Mr. Diaz for the defendant. Good morning, Ms. Gledhill. Mr. Diaz, what's the status today?
So, Your Honor, we filed some motions last night. The state and I have had an opportunity to speak about them. I believe on a couple of them, there's some form of an agreement that we'll come to that will resolve, I think, some of the issues. Based on a conversation that I had with Ms. Paulus in October and the trial getting canceled, I filed a motion in limine that the state would like an opportunity to look at and consider. So I think as of right now, and in speaking with the state, I'm also toying with the possibility of another one, which they're not agreeing to, but they don't have an objection to me kind of looking at and ferreting out and then potentially filing. What we're asking for collectively is a status hearing on the 16th of January. And then from there, we would set trial dates and motion hearing dates should they become needed.
Let me check. The only problem with, sorry, I've lost my voice, Your Honor. The only problem with the 16th is I'm potentially in trial. I prefer a different date.
If we want to do the second, that's fine as well.
Let me look. Sorry, did you say January 2nd?
Correct.
Is there another day? The state might not be available that day due to the holiday.
If the court, would the court be willing to do this on a non-standard calendar? Or should we start looking at February?
And I prefer not to go to February.
And I have a tendency to agree.
I can
so
do the
don't-
2nd, but
I don't know if the court would be willing to put it on the 15th or the 29th, is what I'm asking.
Well, I'm guessing Ms. Paulus is still going to be on trial on the 15th.
but the 29th, I'll be in Brereton's courtroom handling preliminary hearings, so I'd be able to come over here on the 29th.
Okay, let's do January 29th, 9 a.m. for a pretrial conference where we can talk about further scheduling.
Yes, we want a chance to look at the motions, decide if we're going to file a response, and also whether or not they need any sort of evidentiary hearing. And we just aren't, when they were filed last night, we just haven't had an opportunity to review that.
Okay. Anything else we need to discuss?
No, Your Honor.
Okay. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Your Honor, can we call the on-fam matter, please?
3 cases, State versus ONFAM, cases ending 2364, 2924, and 3417. Ms. Whiteway here for the state, and Ms. Lockwood, Ms. Dugan for the defendant. Let's just make sure he is connected online.